Admiral McConnell, thank you very much for your service. I find you to be an honorable man who has served this country under both Democratic and Republican regimes and have no reason to question your dedication to service or your veracity. Let me ask you this. There seems to be some confusion that I hope we can clear up. It is my understanding that when you took over, you realized that the FISA court, a FISA court judge, had made a decision that based on the then current language of the law, which came in 1978, that it now required you to go for warrants in circumstances where you hadn't gone for warrants when the law was first established. Is that true?
Yes, sir, that's true.
And is it true that you attempted to work under the law as interpreted by the court and found that as a result of working under those restrictions, you were, that is your agency, was prohibited from successfully targeting foreign conversations that otherwise you would have for looking into possible terrorist activity?
Yes, sir, that's true.
And is it also true, Admiral, that merely saying that foreign-to-foreign communications would no longer require warrants did not get to the nut of the problem?
That's correct, sir.
And is it also true that because of technology, the way it works, without going into anything that is classified, you specifically target an individual you reasonably believe to be a foreign target outside the United States?
Yes, sir.
And do that without a warrant?
That's correct.
And you cannot beforehand know with any degree of certainty whether that person is going to have some conversations into the United States?
That's correct.
And if you were required, because of that possibility that there may be a conversation into the United States, communication into the United States, you had to get a warrant in each and every case, it would be impossible for you to do the job you've been asked to do.
That's correct.
And you say that because, in fact, it proved impossible to do the job you were supposed to do.
Yes, sir.
And we were excluded from obtaining crucial terrorist-related information from targets overseas that, under the reading of the 1978 law, under the technology that existed at that time, we would have been able to reach without a warrant.
That's correct.
So that what you have attempted to do and what we did in this law was to use the same legal construct, which was to take outside of the requirement for warrants those kinds of communications that weren't anticipated to be protected by the Fourth Amendment because they were directed at individuals who were foreign in foreign countries.
That's correct.
And that because on occasion, and we're saying occasionally because compared to the number of communications we're talking about, these are occasional communications into the United States at the other end. You have devised a system of minimization which is basically the same minimization we use in criminal cases.
Yes, sir.
And in criminal cases, when we get a wiretap on a suspected mafia member, we target the mafia member, we target the particular means of communications he uses, not knowing ahead of time who he's going to communicate with in the future.
That's correct.
And that on those occasions when he does communicate with someone that has nothing to do with his mafia connection, we minimize.
Minimize.
And you're doing the same thing now.
Yes, sir.
And you had experience minimizing when you were head of the NSA.
I did. And
you feel an obligation both legally, morally, and ethically to follow the strictures of the law there.
Yes, sir, indeed.
And so when you tell us that you haven't wiretapped any individual in the United States without a warrant, you were saying you haven't targeted them as the individual from which you are seeking information. You're not saying that you didn't pick up inadvertently conversations that came into the United States, correct?
That's correct.
And when you did, you applied minimization as we do on the criminal side, which we've been doing for 30 or 50 years.
And if they were a target of interest, then that would mean we would have to now get a warrant if it was someone,
And that is still the case.
That is still the case.
And as I understand it, there's some concern that the new language could reach domestic-to-domestic communications or target a person inside the U.S. for surveillance. At least this is what some of the critics have said. because that information is being sought, quote unquote, concerning persons outside the U.S. If that criticism were true, it would have to mean that we are not looking at the pre-existing language of FISA defining electronic surveillance, correct?
That's correct, sir.
So that we have to take the entire law into effect with the amendments we have placed here, and you still have that category of electronic surveillance for which you do have to get a warrant, correct?
That's correct, yes, sir.
And nothing in this act changes that as far as you're concerned in the operation of the law.
That's correct, yes, sir.
Thank you very much.